Hi everyone, hope you all are doing great. Today we are going to discuss an important case law of family law. The name of the case is Samar Ghosh versus Jaya Ghosh 2007. The case is based on the concept of mental cruelty. In this case, both the parties were IS officers. They got married in Calcutta on 13th of December 1984. The respondent was a divorcee and she had a daughter from her first marriage. Now we are discussing the conflict happened in the second marriage. Soon after the marriage, she asked the appellant not to interfere with her career. She had also unilaterally decided not to give birth to a child for 2 years, and the appellant should not be inquisitive about her child, and he should stay away from her as far as possible. According to the appellant, there was demand of emotions from love and affection to future planning. Though he tried to reconcile to the situations created by the respondent, despite of everything, the respondent refused to cohabit and started living separately since 27th of August 1990. It is to be noted that the appellant was not allowed to show affection to the daughter of the respondent, although he was good to the child. Now, coming to the decision, the Honorable Court came to the conclusion that there cannot be any comprehensive definition of mental cruelty. Since cruelty varies from case to case, it is subjective in nature. It varies from person to person according to their upbringing, sensitivity, educational background, financial positions, social status, customs, religious beliefs, family background, culture, etc. Therefore, the best way to adjudicate such cases would be to evaluate it according to its facts and circumstances. There is no straitjacket formula or fixed parameters to determine mental cruelty in matrimonial matters. However, the court enumerated instances of human behavior which may be relevant in dealing with the cases of mental cruelty, such as number 1, considering the complete matrimonial life of the parties, acute mental pain, agony, and suffering as would not make possible for the parties to live with each other could come from the broad parameters of mental cruelty. Second, on comprehensive appraisal of the entire matrimonial life of the parties, it becomes abundantly clear that situation is such that the wronged party cannot reasonably be asked to put up with such conduct and continue to live with other party. Third, mere coldness or lack of affection cannot amount to cruelty. However, frequent rudeness of language, petulance of manner, indifference, and neglect may reach such a degree that it makes the married life for the other spouse absolutely intolerable. Fourth, mental cruelty is a state of mind. The feeling of deep anguish, disappointment, frustration in one's spouse caused by the conduct of other for a long time may lead to mental cruelty. Fifth, a sustained course of abusive and humiliating treatment calculated to torture, discommode, or render miserable life of the spouse. Sixth, sustained unjustified conduct and behavior of one spouse affecting the physical and mental health of the other. The treatment complained of and the resultant danger or apprehension must be very grave, substantial, and weighty. Seventh, sustained reprehensible conduct, studied neglect, indifference, or total departure from the normal standard of conjugal kindness, causing injury to mental health or deriving sadistic pleasure can also amount to cruelty. Eighth, The conduct must be much more than jealousy, selfishness, possessiveness, which causes unhappiness. However, an emotional upset may not be a ground for grant of divorce on the ground of mental cruelty. Ninth, mere trivial irritations, quarrels, normal wear and tear of the married life, which happens in day to day life, wouldn't be adequate for grant for divorce on the ground of mental cruelty. 10th, the married life should be reviewed as a whole, and few isolated instances over a period of years will not amount to cruelty. The ill treatment must be persistent for a fairly lengthy period, where the relationship has deteriorated to an extent that because of the acts and behavior of a spouse, the wrong party finds it extremely difficult to live with the other party any longer may amount to mental cruelty. 11th, if a husband submits for an operation of sterilization without medical reasons and without the consent or knowledge of his wife, and similarly if the wife undergoes vasectomy or abortion without medical reason or without the consent or knowledge of her husband, such an act of the spouse may lead to mental cruelty. 12th, unilateral decision or refusal to have intercourse for considerable period without there being any physical incapacity or valid reason may amount to cruelty, which happened in this particular case. 13th, unilateral decision of either husband or wife after marriage not to have child from the marriage may amount to cruelty. This also happened in this case. 14th, where there has been a long period of continuous separation, it may be fairly concluded that the matrimonial bond is beyond repair. The marriage becomes a fiction, though it is legal. By refusing to sever that tie, law in such cases does not serve the sanctity of marriage. On the contrary, it shows scant regard for the feelings and emotions of the parties. In such situations, it may lead to mental cruelty. Now, coming to this case. In this case, there was ample reasons to point out that there was mental cruelty, from continuous demand to unilaterally deciding to not have child for 2 years and refusing to reside with the appellant without any justification amount to mental cruelty. Hope you got an idea about the case law. Please do not forget to like, share and subscribe to the channel. Thank you so much for watching. Bye bye.